Hello everyone. Welcome to another episode of SEO Explains. Do you recall how about 15 years ago, flipping through the newspapers, circling movie showtimes on TV guides, and using your DTH recorder to tape films was a daily ritual? This was before over-the-top providers gave us entertainment at our fingertips. A recent judgment on the taxes levied on direct-to-home providers stirred up some nostalgia about how different things used to be back then. The court was deciding if DTH providers were performing the service of disseminating the right TV signals to our screens, or if they were providing entertainment. The judgment was State of Kerala versus Asianet Satellite Communications, a case I added to the Supreme Court Observer Law Reports, the SEO's compilation where we report and summarize on the 5 most important judgments of the week. Justice B.V. Nagaratna had written the judgment, adding to her repertoire of decisions on the separation of powers between the union government and the states. DTH providers like Tata Sky and Dish TV had approached the Supreme Court, challenging the levy of an entertainment tax by state governments. They argued that they were broadcasting signals to air channels as a service. They were not providing entertainment. DTH providers believed that state legislations incorrectly taxed them under Entry 62 of the state list. The previous version of Entry 62 allows states to collect taxes for luxuries, entertainment, and amusement. DTH providers already pay service tax to the central government under Entry 97 of the union list. States had a different approach. Invoking the Canadian doctrine of the double aspect theory, they argued that a single transaction can have two distinct elements which are both taxable. Most high courts accepted this argument and found that DTH providers offer both a service and entertainment when they add a show or a movie. As many as 42 appeals against the High Court decisions reached the Supreme Court. The Supreme Court agreed with the High Courts. Justice Nagaratna wrote that by rendering the service of broadcasting, the assessees are entertaining the subscribers within the meaning of Entry 62 of List 2. The court concluded that both the union and state governments possess the legislative competence to tax DTH providers as they are different aspects of the same activity. This judgment arrives at a time when the DTH market appears to be shrinking rapidly. The Telecom Regulatory Authority of India reported that in September 2024, there were 59.91 million DTH subscribers, a sharp fall from 62 million just 3 months before. The financial burden on the DTH market is already substantial. For example, Dish TV recently contested a demand for a licensing fee of over 6,000 crores from the Ministry of Information and Broadcasting. This licensing fee is 8% of the provider's adjusted gross revenue. TRAI proposed reducing it to 3%, an idea that Dish TV has been pushing the MIB to consider. The ministry has yet to respond to TRAI's proposal. DTH providers are also in the middle of a battle for content parity with OTT platforms to allow streaming shows on television. The present judgment adds another component to the rising cost of being a DTH provider. The growth of OTT, increasing cost, and a declining market may have rendered DTH on the verge of obsolescence. For many like me, Sundays spent lounging in front of the TV, watching an endless stream of action movies, will remain the sacred beginning of a lifelong love for the craft. Will the Supreme Court's judgment be the straw that breaks the camel's back? Thank you for streaming in. We will catch you later. Follow SEOobserver.in for more, and as always, don't forget to subscribe. Obviously, it goes without saying that there is no tax on that.